Hello and welcome to Williams Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and on today's episode, I'm joined by my colleague, Zan Gormley, a litigation partner in our Raleigh office, who is here to talk about multi-employer plans. Welcome back to the Benefits Companion, Zan.
Thanks for having me.
So today, Zan is going to talk about multi-employer plans, what they are, how they work, why they're important, and some critical litigation issues that people who deal with employee benefit plans should be aware of. So just to start off, Zan, what is a multi-employer plan?
Simply stated, a multi-employer plan is a collectively bargained plan in which employees from multiple employers participate. They are sometimes referred to as Taft-Hartley plans because they were created by the Taft-Hartley Act, which is also known as the Labor Management Relations Act of 1947, which was passed to regulate labor unions.
Okay, so how do these plans work? In other words, what makes them different from a single employer plan?
Right. So in a single employer plan, you have one employer that sponsors a benefit plan for its employees. Easy enough. And the contributions to that plan come from just that employer and oftentimes its employees. With a multi-employer plan, you have multiple different employers who are not affiliated, separate companies altogether, across a similar trade, craft, industry, or geographic location that all contribute to one plan that provides benefits to each of their respective employees. Instead of directly sponsoring a health plan or retirement plan, for example, for its unionized employees, each employer will make contributions to that multi-employer plan, and the plan will then provide the benefits. So it's up to the multi-employer plan to sponsor, to administrate the plan, to deal with the benefits. Once the employer makes the contributions, generally speaking, its obligations to the plans are taken care of.
So you're referring to employers making contributions to the plan. What establishes the amount of those contributions? Can each employer just contribute however much or little they feel they can afford, or is there something else that sets an objective standard for the employer contributions?
Yeah, that's a great question. So they're collectively bargained plans, which means when an employer who has a unionized workforce enters into a collective bargaining agreement with the local union, or in some cases it might be the overarching national union, that collective bargaining agreement defines what amount of contributions you make. So for pension, it's going to be X amount of dollars per employee per pay cycle. For healthcare, it's going to be X amount of dollars per employee per cycle, and so on and so forth down the line. Employers cannot deviate from that. Obviously, during the bargaining process, that amount is closely and toughly negotiated. Actuaries are typically brought in to decide what amount of funding will be needed to provide all the needed benefits going forward. And then once that rate's set, you are locked into that rate as an employer for the duration of the collectively bargained agreement. You can engage in side letters over the course of it, maybe to adjust that, but by and large, the CBA is going to establish what the rate is for the duration of the CBA.
So what exactly is the relationship between the plan itself and the union? Is the plan part of the union, or is it controlled by the union?
That's another great question. Because these multi-employer plans are a product of collective bargaining, they are associated with labor unions, and they will typically have a name that denotes a labor union. The Teamsters Pension Plan, the International Association of Machinists Benefit Plan, or something along those lines. But it's actually a misconception that multi-employer plans are one and the same as the unions they're affiliated with. They're not. They're not part of the union legally, and they're not controlled by the union legally. They're trust funds. And like any other trust, they are their own distinct legal entity, and they have to be governed by trustees. And multi-employer plans are governed by a joint board of trustees, which consists of equal representatives from both the management side, which is the employer side, and the labor side, which is the union side. So typically in a plan, you'll find 4, 5, 6, maybe trustees from various contributing employers, right? For some of the grocery store companies that are unionized, you'll have Kroger might have 3 or 4 people from its management and higher up in its C-suite who are on that board. And then on the other side, you'll have representatives from the local unions that typically make up a big part of the underlying employee base.
So why are these multi-employer plans important?
Well, from a broad perspective, they're important just like any other employee benefit plans because they provide health and retirement and other welfare benefits to hardworking people. Obviously, you and I are in the employee benefits space, and we know how important and significant employee benefit plans are to the day-to-day well-being of employees and also for employers who want to provide great benefits for their people. But to be more specific in why are multi-employer plans important? They are important because they provide benefits to a significant amount of people across the country. That might conflict with some people's conception because some people think, well, union membership is not what it used to be during the peak industrial years of the United States. And that's correct. Union membership has declined over the years, and there's no question about that. But according to the Bureau of Labor Statistics, as of 2021, there are still 7 million unionized workers in the private sector alone, and also a large amount in the government sector. But just private sector wise, that accounts for 6.1% of all employees, those 7 million. And additionally, per the Department of Labor, there are over 15.7 million participants and beneficiaries in multi-employer pension plans and 5.4 million in multi-employer health plans. So we're talking about a significant number of people and their beneficiaries who these plans affect on a day-to-day basis. In addition to that, the financial clout of these plans remains really significant. For example, as of 2019, multi-employer pension plans accounted for almost $780 billion with a B in combined assets. So we're talking close to $1 trillion just in multi-employer pension plans alone. Now, they also have a lot of obligations, but still, just in terms of the sheer amounts of cash and investments that they're sitting on, it's a substantial number.
Right. So this is still a significant part of the economy and of our retirement system in the United States.
Absolutely.
So, Zan, you're a litigator. What are some of the critical litigation issues that people who deal with employee benefit plans should be aware of with respect to multi-employer plans?
Well, as with other types of benefit plans, multi-employer plans are no stranger to litigation. Of course, they face many of the exact same issues that other plans face, like claims by participants for denial of benefits, right? You and I had a podcast on that, I think, a year ago about how that's such a big part of ERISA litigation. But there are a few issues that are unique to multi-employer plans as far as litigation goes. Certainly a number of unique issues on the compliance side too, but just talking about litigation, there are a few, and I could talk about them all day, but this is a podcast where we want to get right to it. So I'll just touch on 3 in particular. The first issue is what's known as withdrawal liability. This applies to multi-employer pension plans. And this issue can get incredibly complicated, but a simple way to describe it is that when a participating employer withdraws from a multi-employer pension plan, typically by going out of business or ending its collective bargaining agreement, it will be assessed a statutory penalty representing that employer's share of the plan's unfunded vested benefits. And without getting too technical, what unfunded vested benefits means basically is the difference between how much the plan has in assets and how much the plan will have to pay for the vested benefits that have been accrued by the withdrawing employer's employees at the time of that withdrawal. These amounts can often be very large depending on a number of factors, particularly, as you wouldn't be surprised, how underfunded the plan is. And because of how big the dollars at stake often are, there has been a substantial amount of litigation over withdrawal liability in the years since it became part of ERISA with the Multi-Employer Pension Plan Amendments Act of 1980, which was passed under Carter and signed into law by Reagan.
And withdrawal liability also is a significant issue in corporate transactions, where every purchase agreement that you read will have a rep that the seller does not and has not maintained a multi-employer pension plan. And the risk that they're trying to avoid is taking on that withdrawal liability or being stuck with an obligation to contribute to a multi-employer plan. So it's a big issue in corporate transactions. But without getting too deep in the weeds, what are significant litigation considerations that everyone should know about withdrawal liability?
Sure. Well, the rules for how a plan assesses withdrawal liability and then how an employer must respond to it, challenge it, and then pay for it are complicated and in some cases really strict. I'll give you a very clear example. ERISA mandates that any challenge by an employer to withdraw a liability has to be arbitrated by a specific deadline. And if the employer misses the deadline for initiating arbitration, it has lost its right to challenge the withdrawal liability. It is literally strict liability. That issue has gone up 1,000 times in district courts and the circuits. And by and large, the circuits come down and they say, I'm sorry, this is harsh, but it's what the law says, and I can't go against Congress.
You missed the deadline. It's severe.
Absolutely. Now, what people say is, well, there's a lot of withdrawal liability litigation in district court. What do you mean everything has to be arbitrated? Well, the distinction is there are a number of exceptions to withdrawal liability, and there's also the issue of whether, in fact, you are even an employer, right? And that kind of gets to your whole comment earlier about in corporate transactions, because there are ways in which you can, in essence, take on the withdrawal liability of a previously contributing employer through transactions, mergers, successor liability, also as being part of a control group. So there's a ton of litigation in that regard about, are you really an employer? Are you someone who's taken on it? That's not necessarily subject to the arbitration requirement. But if you are a contributing employer, and there's no question about it, you withdraw and you're assessed, and you want to challenge that, you want to challenge the amount because you think it's based on actuarial assumptions that are unfair or not accurate, boy, howdy, you better initiate arbitration timely or you're stuck with that dollar amount, and it can often be really large.
So the arbitration deadline, it's not about the whether you're subject, it's the amount.
Generally speaking, right. The amount and the assessments that it's based on, correct. And the underlying factors which you might want to challenge, such as your contribution history, whether it's accurate, the level of benefits that your people have accrued, and various other inputs. There are reams of the CFR that get into the calculation of withdrawal liability, and I don't think we want to put our listeners to sleep.
So what's the second issue unique to multi-employer plans?
Sure. Well, the second issue involves delinquent employer contributions and how the enforcement scheme for collecting them is different for multi-employer plans than it is for single employer plans. As we mentioned earlier, the bulk of contributions for multi-employer plan comes from the employers themselves. And because of that, Congress wanted to put some extra teeth into ERISA to deter employers from being delinquent on their contributions to the plans. So under ERISA Section 502G, multi-employer plans can not only recover the amount of the delinquent contributions that an employer owes, but also mandatory additional penalties that consist of liquidated damages and attorney's fees and costs. So if you're an employer and you miss your contribution for whatever reason, you decide you don't want to pay it, you don't have the money to pay it that month. You had the money to pay it that month, but you needed to pay for another expense, right? Cash flow is an issue for everybody. If the plan comes after you to say, make that payment, and you can't work out a deal and they have to sue, by law, the court is going to have to assess those additional penalties. There's no way around it. And there's no defense to that. It's just, that's what the penalties are. So you need to be really careful with employer contributions to multi-employer plans.
So what's the quick takeaway to know about delinquent employer contributions?
Well, both sides of the equation, whether you're a plan or an employer, should really monitor the contributions, because if a delinquency arises, disputes over those can get expensive real fast and become a zero-sum game, right? Because the plan's going to say, well, you're late and now you owe this interest, and if I have to sue you, owe these penalties. And the other side is going to say, well, I don't have the money, and can lead to disputes that are no different than typical collections actions, like when somebody's under a contract to pay a vendor and they just can't pay the money, or they don't feel like they should have to pay that much for business reasons. So the best practice, I think, is monitor, and then try to work it out. Otherwise, you're getting into litigation that can be difficult for both sides.
And what's your final issue, third and final issue regarding multi-employer plans?
The third is really, in some ways, the flip side of delinquent employer contributions. It's what happens when an employer contributes more than it's supposed to contribute and wants a refund of that overpayment. Now, to the non-ERISA practitioner, you'd say simple. You just say, hey, I paid you too much, give it back. And if they don't, you go to the court and say, well, they've been unjustly enriched. They're holding on to money that's not theirs. Well, it's ERISA and it's trust funds. So we're dealing with a totally different set of laws and concepts. In a nutshell, ERISA has a provision in Section 403 that prohibits the assets of a plan from inuring to the benefit of any employer. It's known as the anti-inurement provision. And because employer contributions become plan assets within a certain amount of time after the plan receives them, the anti-inurement provision means and imposes restrictions on an employer's ability to recover refunds of overpayments. So for multi-employer plans in particular, those restrictions are very strict. The overpayments can only be returned if the Board of Trustees determines in its sole discretion that the overpayment was made by a mistake of fact or law, and then decides to return them. So the board can look at why the overpayment was made and say, I agree, this was done by a legitimate mistake. But it could also say, you know what? We've had these contributions for 2 years. We've made funding assumptions based on them. We can't give these back, so you're not going to get them back. And as an employer, you're stuck with that decision. You can't sue to overturn that decision until the board actually makes that decision, right? You can't circumvent the board's process. You have to go through the board, which can be tough. And if the employer does decide to sue to recover it, he doesn't like the board's decision, the reviewing court has to apply a deferential standard to the Board of Trustees' decision. Doesn't just look at this and say, well, what seems fair? What would I do? It has to apply the arbitrary and capricious standard, which asks basically, look, was the board's decision supported by substantial evidence? Was it erroneous on a question of law? If it's not, the court is going to have to, as a matter of law, do what they do under that standard and say, you know what? I might have disagreed with the board's decision, but it's not for me to second guess them. So it's just something to be aware of, and another important litigation consideration with multi-employer plans.
Well, Zan, do you have any parting words?
Well, I appreciate the question. I have litigated each of these three issues extensively. And I can say from firsthand experience that they can become very hotly contested and very complicated, as with most things involving ERISA. So whether you are a multi-employer plan or you're an employer facing issues with multi-employer plans, you need to be really thoughtful and careful in how you approach them. And that starts with enlisting experienced ERISA counsel from the outset, because that can just make it a lot easier to navigate the minefield.
Well, thank you, Zan, for joining us on the Benefits Companion once again. That will wrap up our discussion. Thank you for joining us on this episode of the Mullen Benefits Companion. If listeners have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. And finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.